Hello friends and welcome back to my channel. I'm Chelsea. You already know that. I am quite sure Wiggum is snuffing, harumphing in his love sack. I can't believe I just admitted that. In the love sack right there. So sorry you won't see him during this video. It's okay. You didn't see him in many of my other videos. You only saw him in live streams. It's fine, don't worry. Anyways, please subscribe, like, and comment because today we have quite a messy video for you. I'm not gonna be messy. I mean, this is a big pour, so I might be messy. But to get through this, I'm gonna need this. If y'all thought the MLM Boo, the one that was selling literal dirt and mud to people, if you thought that was unhinged and messy, if you thought that the interim CEO's, past CEO's wife, whoever she is, in Young Living, sending out a booklet talking about demons, if you thought that was unhinged and messy, you have no idea. This MLM Awakened has absolutely been one of my favorite things to come about. Obviously, I don't want it to be about. I don't want it to scam people. But let me tell you, the past few days, nights, I have just been curling up on the couch, putting on Manifest. I've been binge watching it. Yes, Ben, my son, Stone, is the worst character ever written into any form of media. Why is he such a mouth breather? Why doesn't he close his mouth? It's so frustrating. He's just like this. And then as the seasons go on, you just see more of his bottom teeth. It's the worst. Anyways, I hate to love this or love to hate this more than I love to hate that character. Does that make sense? It should. So this is a 36-page document that I have absolutely loved going through and highlighting. It is so messy. And this is a lawsuit that involves multiple parties. Actually, three main parties. One of them being Awakened and the owners or C-suite people, basically the owners of that business entity, of that multi-level marketing company. In my past videos that I've done on Awakened, I think I did one on them on like a Zoom call that they did. They're trying to like sell NFTs and diet pills. It's like, this is beautiful. What? What are you doing? That video was pretty unhinged. The one we're going to watch in a second, I think it's better if we go over all this first, and I'll make it super quick. I'll give you a quick rundown, read over the parts that I highlighted, and then tell you like what it means basically, and just go over it in layman's terms. Quickly, did you know that I'm not a lawyer? I am not a legal representative of anyone. Not even myself, not even Wiggum. Wiggum is my lawyer. I would love to go to law school. That is, can I afford it? Probably not. But would I love to? Abso-freaking-lutely. Am I actually working towards that? Yes. However, I'm not a lawyer. This is not legal advice. I'm just going over these documents and reading them and interpreting them as I understand them. And really, this is all my own opinion. But really, I'm just going over all the court documents and what is written in here. Okay? Okay, so for a quick synopsis, there's this company called First Fruits Business Ministry. Like, pick a lane. What are you doing? We're going to call them FFBM, which is how they are referred to in these documents. So FFBM is a business entity, a company that made a drug called Trisonex. I'm probably going to butcher the names of these things because they're like, pharmaceutical names are, well. So they sold it to, from what I am understanding in these documents, I could be wrong, but they sold their IP, their intellectual property, patent, or like the rights to the patent, something like that, right? And like the licensing and all that, to Imagentex. I'm probably pronouncing that wrong too. Get over it. Imagentex sold the rights, or was like about to sell the rights, to this company called Tripharma. The fruit company. It's not a fruit company, but FFBM, Imagentex, and Tripharma, right? Okay. And Tripharma was supposed to be able to use like the licensing and all that until October 2014, okay? And not after. Imagentex, again, butchering that, I don't care, apparently went bankrupt, and I'm going to go over all this too. But this is just like a bird's eye view of it. And then everything was like reverted. So the deals and stuff like went back or something. And so then Tripharma, I guess, didn't have like licensing rights or like the rights to anything regarding that drug anymore. And all that like reverted back to FFBM. Okay. Allegedly. I'm just going to keep saying allegedly because I want to make sure I'm like not going to get dude. I probably will. It's fine. Tripharma seems like they all about suing people. And then Tripharma sold/licensed the rights to sell, promote, and market the drug to Awakened, the MLM, even though they did not have the rights to do so. Awakened has been selling that product, well, their product, ZENITH. And they have been saying that, or like showing this patent and showing like this triple blind study, blah, blah, blah. Well, that information that they were showing was doctored, like they edited it. It's not actually for ZENITH. It's for the other product. It's for that Trisonex product, that other weight loss product that the FFBM company made and like patented and like had a bunch of studies done for, right? That's not good. Don't do that. Tri-Pharma like didn't have the rights to like sell the stuff. So we're gonna go over that real quickly. Listen, I didn't think, someone sent me this and they were like, hey, here, like, this is insane, look over it. And I looked over like the first few pages and I sent it to my lawyer right away because I was like, girl, grab a drink. The tea is hot. This is crazy. Like, this is so petty. This is so petty. I'm also fascinated by this stuff, and I know a lot of y'all are as well. If you like people going over stuff like this and you actually want someone who's credible to tell you this stuff, go watch Emily D. Baker. She's quite entertaining. All right, so page 1 just goes over who's involved in the case. I don't care about that. So this is a second amended counterclaim, basically meaning that at first Tri-Pharma tried to sue First Fruits Business Ministry, FFBM, and they've been like you'll see a pattern that like every time something is like settled and like the courts make their decision, the courts with a capital C, meaning the judge, and everything's good, or so we thought, Tri-Pharma turns right back around and it's like, hey, guess what? No, we're gonna do this again. We're gonna, submit another appeal, or we're gonna, ask for an amendment or for whatever. All right, so on this first page, again, just going through this real quick, and I will screenshot all of it, and then Ethan can put it up on the screen. And again, I'm gonna go over it in like layman's terms with you as well, because I know it can be really confusing sometimes. If you don't speak legalese, I hardly do. I understand enough of it to, get me in trouble. Okay, so going over the parties. So on page 2, paragraph 1, technically paragraph 2, but whatever. We're going to go by the lines because it does, thank God, show the lines on here. Basically, just going over all of the parties that are involved. So FFBM is a limited liability company, organized and existed under blah, blah, whatever. FFBM did have to file Chapter 11, which is bankruptcy. And that was on October 7th, 2022. I was about to say last week. Girl, we're not time traveling. It was not last week. It was a month ago. So keep in mind, FFBM. And you might be like, Chelsea, I don't understand that. You're going to get it and you're going to understand why this is so insane. Please stay with me because this is wild. That this MLM is doing this is so crazy. This company that originally created, worked so hard for, this one product that the MLM Awaken is allegedly, fraudulently claiming the rights to and promoting and all that, and that they've allegedly falsified documents. I mean, that isn't alleged, that has been proven, but allegedly that company has launched. So while this company's launching and lying, they've been caught lying and they've ignored cease and desist. The company that actually worked their off to, and I don't know any of these people, and actually did the double-blind study from the University of Connecticut, I believe UConn, and all that, they had to file Chapter 11. They had to file bankruptcy because of all this that this other company and this one has put them through, allegedly. How crazy is, like, that's so messed up. So yeah, so they had to file bankruptcy on October 7th, so about a month ago. This amended pleading is filed in accordance with the 20-day deadline set forth, blah, 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 whatever. Okay, so without prejudice, Tri-Pharma's motion to dismiss the counter complaint. So this is their rebuttal to Tri-Pharma coming at them being dumb, basically. Or rather, Tri-Pharma trying to dismiss whatever they were wanting to do. So what it is, where we are in the timeline, basically, is that FFBM sent Tri-Pharma and Awakened, and we'll see that in a minute, sent them a cease and desist, sent all of them cease and desist. And again, like I said, we'll go over that in a minute. They've ignored it. They've not tried to, allegedly, and they've not rectified it or done anything like that, according to these documents. Which is insane that they've just continued to launch and they're like crying on a live stream. What? It's ridiculous. Oh my God. What happens with that when you ignore a cease and desist? Either the people don't move forward or they do. So it looks like FFBM moved forward and then Tri-Pharma did a motion to dismiss. And then this is the response to that, I'm assuming. Again, I'm not an accountant. Listen, I'm not an accountant either. I'm not an accountant. I'm not a farmer. I'm just a lady with a camera, okay? I'm just a lady with a camera and a bulldog. That's all I got. So that is that person. And then there is Tri-Pharma, who is the other counter defendant. And then there is Evan Dameshek. He sounds like a piece of and that's my opinion. I don't care if I'm pronouncing his name wrong. With that one, I really don't care. Is or was the president and CEO of Tri-Pharma. Your boy was convicted of some craziness. That was a twist I was not expecting. If y'all have any insane court documents that you want me to, or like lawsuits that you want me to look over, girl. And then another counter defendant is Vital Nutrition, which apparently is also owned or controlled by the Dame Shek guy. All of this, the whole parties section is just explaining who like each party is and why they like should be involved in this and all that. And then it's going to refer to Dame Shek, Vital, and Tripharma as the Tripharma defendants. And this is where the Awakened part comes in. And then counter defendant Awakened LLC, Awakened Limited Liability Company, Utah Multi-Level Marketing Company, counter defendant Danielle Mioli. I don't know how to pronounce her name. That's fine. Again, don't care. She seems like person in my opinion. She's the CEO and an owner of the Awakened entity, and then it goes down to Rodney James, hereinafter referred to as James, as a controlling partner, officer, member, whatever, owner of Awakened entity as well. And he is the registered agent for of services. It's like who like the like legal documents are supposed to go to, I think. I don't know. Who am I? A business owner? No, I'm not. Okay, and then James Roufs, another controlling member of Awakened. And this one's interesting because James Roufs, let's just call him Roufs, is a longtime associate and business partner of Dame Shek, the guy who was the CEO, C-suite level, whatever, controller of Tripharma and the other Vital company. And he has a history of assisting Dame Shek with trying to deprive FFBM of its rights to the intellectual property at issue in this litigation. Awaken and its officers, for purposes of engaging in the fraudulent conspiracy, forming the basis of this counterclaim. So basically just saying like they're all working together. Ralph's assisted the other counter defendants with stealing and reverse engineering the patented formula that Awakened is using for its ZENITH product. Also, let's keep in mind, it doesn't matter if you're like, oh, well, it's the same product, so like those studies still apply to the product that we're selling. No, that's literally not how science works. It's not how that works. It has to be the exact same thing, like not how that works. So there's Brian Miara. I don't care and I don't know. So Brian Mara is an officer, partner, and or controlling member of Awaken. He's also the #1 master distributor with several thousand people reporting back to him. That is insane. Like, I do not think it's okay for people on the C-suite level or ownership level, corporate side of an MLM, like leadership at all, to be on like the MLM side as well. That is so backwards and just not okay, in my opinion. I think that is extremely unethical. All of this is extremely unethical. We're only on page 4. All right, so Mioli, James, Ralphs, and Mara, all 4 of the people named in this that have to do with Awakened, the MLM that we're talking about, are sometimes collectively referred to the Awakened individual defendants. Okay, and then the rest just says basically that they represent like the company like as a whole, and nothing is going to happen in the company without them knowing about it because like they own it. The next parts are just basically saying jurisdiction and applicable law. It's boring. You don't need to know about that. And then let's go ahead and get into the summary of the counterclaims. So line 11 is where we're starting on here. And it's talking about the ongoing fraudulent conspiracy by counter defendants, which is a quick reminder. Counter defendants mean all of them. So Tripharma, which is that Dame Shek guy as well. And then also Awakened. Okay, so Awakened and Tripharma, and then that Dame Shek guy too. Okay, and then like the other Vital, whatever company that he has. I know it can kind of be confusing. If I need to, I'll draw like a little map for you. Okay, so FFBM's counterclaims concern an ongoing fraudulent conspiracy by counter defendants to pass off FFBM's revolutionary weight loss ingredient, Tricenex, which FFBM markets and sells as part of its weight loss product, Trim Fit for Life, as counter defendants' own product, ZENITH. So, layman's terms, I'm sure you don't need me to say it, but just in case, FFBM is concerned or alleges that, which I mean, it's kind of been proven already, but FFBM is alleging that Awakened are trying to pass off FFBM's own product, Trim Fit for Life or whatever it's called, as ZENITH, the product that Awakened sells, and like being fraudulent and like stealing it basically. As detailed herein, Trinex, I'm going to keep mispronouncing that, it's going to be great, is a patented ingredient that has been subject of multiple clinical trials, including a controlled trial conducted at the University of Connecticut, UConn, just in case, you're not a collegiate babe, and published in the European Journal for Applied Physiology, known from here on out as the EJAP, the EJAP publication. Tricenex is a proprietary blend of modified cellulose and blah, blah, blah fatty acids under this patent entitled Methods to Reduce Body Fat, referred to here on out as 892 patent. Okay, remember that, 829 patent. In 2011, FFBM paid millions of dollars to purchase all rights to that patent, all rights to the product, Tricinix, and then all rights to the Yukon study and other clinical studies conducted on Tricinix, and then all rights to that publication as well. Possessed the exclusive rights to the Tricinix product, the clinical studies, and the exclusive rights to use and refer to the publication, collectively referred intellectual property, since October 2014. So they applied to be able to do all that in 2011. They paid millions of dollars to do that, and then they have possessed the exclusive right to that since October 1st, 2014. Now, that is a very important date. FFBM, however, has recently discovered earlier this year that Tripharma defendants falsely represented to the multi-level marketing company Awakened and its representatives that Tripharma had the exclusive rights to the intellectual property, and that Tripharma could assign these rights to Awakened through this fraudulent licensing agreement. Awakened and the Awakened individual defendants are now falsely claiming that it has exclusive rights to the 892 patent, which that patent has expired. I didn't know that patents expire. I had no idea. They do, apparently. And the exclusive rights to the intellectual property, which means like the clinical studies, the publication, like all that. Exclusive rights to everything having to do with the Tricinix product, Tricinix, whatever. Awakened and the Awakened individual defendants have been rebranding the Tricinix products as Awakened's own product, ZENITH. Part of the rebranding, the counter defendants have intentionally doctored the publication to replace the trade name Tricinix with ZENITH. How insane is that? That's illegal. That's false advertisement, baby. That's illegal. You can't do that. A true and correct copy of their doctored study is Exhibit B, whatever. Okay, so the counter defendants have provided the doctored study to prospective distributors who have signed up for Awakened's multi-level marketing scheme to sell and distribute the sham product ZENITH, which Awakened has estimated will result in more than $75 million in sales. Counter defendants have also heavily promoted the ZENITH product through various YouTube presentations that falsely represent ZENITH as the subject of the clinical study when it was not. These presentations have also falsely touted that ZENITH is supported by a worldwide issued patent, while not disclosing that the underlying 892 patent has actually expired. The presentations have also falsely claimed that ZENITH product is supported by a secondary patent that is and has been exclusively owned by FFBM since it was obtained in 2020. Wild. So they're just like, I cannot. So they're just taking everything is what it sounds like. Allegedly, don't sue me, please. Okay, so this is taking me forever, so I'm most likely going to have to do the lawsuit in one video, that's this video, and then a Zoom call review in another video. But this is so wild, and I'm really hoping that Ethan can, make this cohesive, because I feel like I'm, reading things off, and then I'm like, this is crazy. Then FFBM brings the counter complaint to pursue damages arising, false scheme, blah, 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 whatever. So you stole our stuff, you're, causing us damage, and you're referring to this intellectual property and this patent when you don't have the rights to. Pay us. In my opinion, that's what that's saying. They are pursuing damages. And then statement of facts is about to get spicy. Grab a drink or a snack or something, please. It's about to get so spicy. So FFBM purchases the intellectual property from Imagentix. All right, so in 2005, way long ago. All right, so this is where things get a little bit tricky. So that 892 patent, which was entitled The Methods to Reduce Body Fat, the initial assignee of the patent was the Regents of University of Minnesota. I don't really know what that means, but basically, I don't know, the University of Minnesota had, they made it or, did it. I registered it. I don't know. In 2005, UMin, so cute, entered into an exclusive patent license agreement, EPLA, you'll hear that a lot more now, third-party Imagentix, Inc., the University of Minnesota retaining ownership of the patent. So the patent was not owned by Imagentix yet, right? In 2006, Imagentix sub-licensed most of the patent rights to Tripharma under an exclusive marketing and supply agreement, which was later amended. A copy of that is whatever, blah, blah, blah. In 2011, Imagentix and FFBM, through FFBM's principal, Roger, which that means owner, Catarino, began negotiations where Imagentix would purchase the 892 patent from MU and in turn sell the patent and related IP to FFBM. So 2011, FFBM has all rights, intellectual property, the IP, baby, that IP, to the patent, therefore like the product and all that, and can sell and buy it and all that. ImageNtext did acquire the patent from UMin, University of Minnesota, and in 2011, ImageNtext and FFBM signed an agreement to assign the intellectual property to FFBM. So again, March 2011, okay? FFBM provided ImageNtext with a bunch of money and shares of their company, whatever, okay, and in exchange for the IP. So they was giving them a lot. And that was for all rights of the patent, all formulations of that drug. The ImageNtext Tripharma arbitration, at the time, the intellectual property was assigned to FFBM. ImageNtext and Tripharma were embroiled in a contentious JAMS arbitration over their respective rights under the EMSA. FFBM had no involvement with the arbitration, but the AAPO, what does that mean again? Agreement for Assignment of Patent and Other Property, provided that FFBM's rights to the intellectual property were subject to the outcome of the arbitration. Tripharma ultimately prevailed in the JAMS arbitration, with the final award being in November 2011. Tripharma's licensing under the EMSA, whatever agreement, was for an additional 2 years with a fixed end date of October 1st, 2014. That means that Tripharma would only have the rights to whatever, to the intellectual property, all that, until 2014 and not after. So then after that, it would go back to FFBM, right? FFMB. What the hell is it called? FFBM. So quick little recap. I know it's a lot, believe me, but it's about to get absolutely ridiculous. It took me twice to go through it to be like, holy wow. FFBM made this product, right? And they were buying the rights to the patent and intellectual property and all that so they could sell it and do whatever with the product. Now, the company that they were getting the patent or whatever through, ImageNtext, however you pronounce that, again, I don't know. They were currently going through arbitration with Tripharma and basically seeing like who gets like the rights to what with like a bunch of their patents or something like that, right? I know I'm probably getting like a few little tiny things here and there wrong, but I'm just trying to break it down for you really quickly. Again, what I'm saying right now is not a fact, okay? I'm just trying to break it down for you so you get it. So FFBM created this product. They were trying to buy the patent and all that from the place where they got the patent or ImageNtext, whatever. And then ImageNtext was going through arbitration, Tripharma, and then Tripharma unfortunately won. So then Tripharma really had rights to the intellectual property for that drug and for whatever FFBM was trying to buy from ImageNtext. So FFBM unfortunately couldn't use any of that stuff until after October 1st, 2014, because that is when the deadline, that's what the ruling was, is that Tripharma would be able to have like the rights to this until October 2014. Okay? That's it. That's where we are right now. Not right now. It gets way worse. Like I said at the beginning of this video, Tripharma and FFBM went back and forth. It's like when your friend breaks up with their significant other and then gets back together 40 times and it's just like, I'm over it. Like, I feel bad for the courts by this time. And that rarely ever happens. It's like, can y'all stop? So 2013 judgment entered by this court. We're only on page 10 of 36. We're definitely going to have to do a two-parter. Tripharma sued FFBM and the heads of the company, Mr. Catarino, that's his name, and Mr. Greg Gus in March 2012. The default judgment ultimately was entered against FFBM. So basically what happened is that I'm sure probably, I don't know, but FFBM was probably trying to like get the rights back from them within that time that ruling was made, that Tripharma would have access to it until October 2014. 2012, they were like, gimme, I want it. And then the courts were like, no, Tripharma holds exclusive rights to use the patent until October 1st, 2014. Until October 1st, 2014, Tripharma holds the exclusive rights to sell, market, and distribute products covered by the U.S. patent, blah, 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 and exclusively market and sell such products referring to this patent and the University of Connecticut study and its contents. Now, the judge also included that an injunction provided that the defendants refrain from selling or marketing the product within the scope of the 892 patent until October 2014. 2014 date was, of course, because the end date of Tripharma's license that had been included in the arbitrator's final award. So basically that just means that FFBM could not use any of that or sell that specific product until after that date, and Tripharma could sell that product, market it, whatever, before that date, right? While the default judgments, basically not letting FFBM do anything with the patent or sell anything, was devastating to the business and livelihood, they did honor the court's decision and refrained from using the intellectual property through October 1st, 2014. So they were like, listen, we're going to respect the ruling and we're not going to do it. All right, we're going to let them have it. And then afterwards, it's ours. Now, Imagentex files for bankruptcy and FFBM terminates the limited patent and licensing rights Imagentex still possessed. The company that made that deadline basically originally filed for bankruptcy in 2012. I know this is a lot, guys. I'm really sorry. Oh my God, this is going to be like a 7-part video. Okay, so the agreement included a provision providing for termination if a party filed bankruptcy. As a result, any rights Tripharma conceivably had under the agreement were terminated upon Imagentex bankruptcy filing. Just like with Tripharma in this situation, FFBM, as a part of that agreement between University of Minnesota and Imagentex, had the right to terminate Imagentex's 892 patent license upon Imagentex's bankruptcy filing. So basically in this agreement that Imagentex had with Tripharma, from what I am seeing, in that agreement, if one of the companies went bankrupt and essentially closed down, then that means that they had the little fine print, the little clause in there, that what would happen is that whatever they agreed upon would revert. So therefore, FFBM learned about Imagentex's bankruptcy filing. They were like, oh girl, what? This about to revert. So then they issued a written notice of termination of Imagentex's patent license rights. The limited rights that Imagentex had retained in the 2011 agreement, which only consisted of an exclusive license to manufacture, market, and sell the capsule for animals, were terminated. 2013 settlement with Tripharma. So even though Tripharma had specifically requested the arbitrator extend the license rights for only 1 2-year term, with a fixed end date of October 1st, 2014, Tripharma and that Dame Chef, you forgot about him, didn't you? He sucks. Top person there or whatever. He controls the company. Later decided that they were not content with the arbitrator's ruling that had granted Tripharma's own request. So basically he wasn't happy with the October 1st, 2014 ruling and wanted it to be extended. But it's that's what you specifically asked for. So in an attempt to secure the rights that Tripharma did not request in an arbitration, I love lawsuits. Court documents are so sassy. I love them so much. August 13th, Tripharma had entered a settlement with Imagentex as part of the Imagentex bankruptcy action. The settlement was approved by the bankruptcy court in November 2013. In its second amended complaint filed in this action, Tripharma contends that it is this agreement, bankruptcy action, that settlement with Imagentex, protected its IP rights. And then it says, but the agreement did no such thing. You tell them, girl, you tell them. While the agreement did state that Imagentex was providing Tripharma with royal-free license to the intellectual property in perpetuity, which means forever, or with no end date. Settlement agreement also provided that whatever rights Imagentex was given to Tripharma were subject to the rights FFBM, the actual owner of the patent and IP, already possessed. And then super sassy last line here on page 11, Imagentex could not give anything to Tripharma that Imagentex did not own or have the legal ability to give. So that wasn't theirs to give, Anyways, the court denies Tripharma's attempt to use Imagentex settlement agreement as a basis to change the October 1st, 2014 deadline. September 2014, it's a month away from their deadline of them not being able to use anything anymore. I don't know, it doesn't seem like they've done anything with it. I don't know, but they are scrambling and they are trying everything they can to try to change that and be oh no, but see, this entire thing's a cluster for sure, but yikes. Okay, so ultimately the court denied this 2 months after the deadline, December 8th, 2014. This is super important though. So in its ruling, the court noted that the transfer of rights from Imagentex to Tri-Pharma would be ineffective to the extent that Imagentex did not have the rights to convey. So basically just saying like, and it actually says it right here on line 22, what rights Imagentex had to the patent, whether it had any rights at all. At the time it was going to transfer those rights to Tri-Pharma during the bankruptcy proceedings is not a question properly before the court in this litigation. But also, you can't give someone rights to something that you don't own. Tri-Pharma's unsuccessful efforts to obtain the rights it never had so sassy through another settlement with Imagentex. Again, they just keep trying and trying and trying. Again, I mean, this is 3 years later in 2017. This is absolutely crazy. So after this court declined to extend the injunction, like the deadline of like October 2014. Also, injunction means like keeping someone from doing something. So basically keeping FFBM from selling anything and making it so that only Tri-Pharma could sell it, have the rights to it, whatever, for that certain time. Obviously, that's null and void because Imagentex went bankrupt and those provisions were made in that contract. Imagentex bankruptcy action unsuccessfully attempted to obtain the rights it most clearly did not have. The Honorable Margaret Mann ultimately denied an Imagentex trustee's motion to approve the settlement. Okay, so FFBM contends the settlement. It says that it ignores the established litigation between it and Tri-Pharma in federal court and the Central District of California. The court agrees. To extend this provision differs from findings made in district court, and it cannot be a part of the settlement that the court approves or binding on the parties. Tri-Pharma's proposed statement ignored the rights established. Bankruptcy court was not going to expand Tri-Pharma's rights beyond the 2014 set date in the default judgment. So again, Tri-Pharma, no, you cannot go past the October 2014. That's not going to happen. Please stop. Okay? For the love of God, please stop. Oh, guess what? Section H, in bold, Tri-Pharma refuses to take no for an answer and forces FFBM to file another adversary proceeding, resulting in Judge Mann confirming the 2013 settlement agreement did not impact FFBM's right to the intellectual property. So basically, they tried to, again, challenge it, and the judge was like, no, what are you doing? Stop. Like, they have the rights to it. You don't. This part's super spicy. So Tri-Pharma refused to take no for an answer. Instead, Tri-Pharma continued to contact FFBM customers and asserted that it had the rights to the patent, despite every court that had considered the issue rejecting their arguments. So just straight up lying. In fact, in May 2018, 4 years after their deadline of like when they don't have the rights to it anymore. And multiple courts have agreed with that. Just before FFBM was to close a licensing agreement with a new customer, so they were about to close a deal, baby girl. They were about to make that sale. Counsel for Tri-Pharma sent a cease and desist to FFBM, once again claiming exclusive rights for the intellectual property. I wish they would have just said F you, but the reason why it's phrased like that is to not make it seem, I don't want to sound like I'm like not on the side of like the little guy and like the person who's like the company that's like clearly in the right and like being over here. But the reason why they phrase it like that is to try to just flat out show or build the narrative, which it could be true. I mean, I think it is, just my opinion. Tri-Pharma clearly is like, oh, you're about to like make some revenue, baby girl? No. How about boom, cease and desist. Slap suit. All of it slap suits. Slap suit, slap suit, slap suit. All that. Slap suit is just here to make you shut up and waste your time and money and make you be quiet. Kind of like how Mon8 did to me and then I took down my videos. I know. I'm disappointed in myself too. Anyways, so Judge Mann issued an order in the same judge dealing with this girl. Miss Margaret Mann. I'm sorry you have to deal with this. Judge Mann issued an order in March of 2019 dismissing the action, prejudice against the Imagentex estate, and without prejudice against Tri-Pharma. In the order, Judge Mann made it clear that Imagetex's 2013 settlement with Tri-Pharma did not provide Tri-Pharma with any rights. Get the picture, Tri-Pharma. So again, they're told that they do not have rights to this product, okay? Again, year after year. Like reiterated. 23, it says Judge Mann addressed in detail how the Imagetex's settlement with Tri-Pharma fully disclosed that whatever rights Imagetex was providing to Tri-Pharma to the intellectual property were subject to the defendant's rights. As a result, Imagetex did not defraud or conceal anything from Tri-Pharma. Tri-Pharma was trying to say that Imagetex like defrauded them and like misled them, I guess. It was so weird. Tri-Pharma's claim that it was defrauded into thinking that the settlement eliminated any rights of FFBM by representation made by Infringement in the context of the settlement is not supported by the record. The settlement terms fully and candidly disclose the Infringement FFBM sale transaction did not affect any rights of FFBM in any way. Since the settlement did not impact what rights Infringement or I would be happy if I never heard the word Tripharma again. Tripharma had to the intellectual property, and because Infringement had not defrauded Tripharma or the defendants, so once again, Judge Mann was like, no, shoo, dismiss, goodbye. Clearly that has happened a lot. A year later, in March 2020, Judge Mann did approve a settlement between the Infringement trustee. I would think the reason why it says like the trustee is just like the person like representing the company since it has gone bankrupt, right? And Tripharma, that settlement did not contain any provision conveying any of the intellectual property to Tripharma. So basically, in March 2020, Judge Mann did approve a settlement between the two companies and like ruled over it in whatever, but that had nothing to do with any intellectual property at all. Tripharma files this action and unsuccessfully moves for a preliminary injunction. Again, just throwing shit at the wall, hoping it sticks. I think, again, a slap suit. I think that's what they've been trying to do for, almost 10 years now? Isn't this crazy? Almost 10 years that they've been trying to do this, in my opinion, so that they can't move forward with this product that they created. This is wild. Filed this lawsuit on October 31st, 2021, last year. May 2022, Tripharma filed a motion for a preliminary injunction asking the court to declare that Tripharma had exclusive rights to exploit the patent and the Yukon study and to enjoin defendants from using the intellectual property. No, you don't. The court denied the motion. So again, no, you don't. And that was July 7th, 2022. In pre-launch by then, right? Or like people were moving over to the company, meaning Awakened. It's so crazy that they did this for almost 10 years. So wild. All right. So as a part of its reasoning, the court determined that the procedural history of the parties, meaning all this messy back and forth, including the orders and judgments referenced above, do not conclusively determine the parties' rights to the intellectual property beyond October 1st, 2014. Parties meaning both. Okay. The court thus concluded that Tripharma had not established a likelihood of prevailing on its argument that Tripharma, and not FFBM, held the exclusive rights to the intellectual property. You're not going to win this argument. Like, please stop. July 2022. Literally, 3-4 months ago? Despite the court not concluding Tripharma had likelihood of prevailing. So basically, even though the court said you got no chance on its claim that it held the rights, Tripharma defendants licensed out the rights to the intellectual property anyway. Allegedly, licensed out not allegedly, they did it, licensed out its rights to the intellectual property to Vital, an entity FFBM believes to be owned and controlled by Dameshek. Good old Dick Dameshek. That would be a really good name, though. Like Doug Dimmadome, home of the Dimmadome, where you get all your big hats and your belt buckles and your Dimmadome. Doug Dimmadome.
My name is Doug Dimmadome, owner of the Dimsdale Dimmadome.
I saw that someone dressed up as him for Halloween. I love that person. Purported, I hate that word, to sublicense these same rights to the multi-level marketing company Awakened. So Tripharma was like, here, Vital, you can have the right. Which, keep in mind, Tripharma and Vital are controlled by the same person, allegedly, Dameshek. He's like, you can have it, and then you can have it, and then Awakened can have it. I misread this part earlier. This is extra messed up. So after they did that, while not having the rights, FFBM discovered the details about this series of assignments, like, you have license, you do it, then pass this down here. After the fact, only when Tripharma defendants on September 2nd, 2022 sent FFBM a cease and desist. That's so sad. Oh my God, imagine, that would suck. A huge problem here is that Tripharma doesn't, it's been ruled in multiple courts, by the court, capital C, that Tripharma doesn't have the rights to the intellectual property. So you can't license out intellectual property. You can't license out a product. You can't license out anything if you don't have the rights to it. I hope y'all are like following along, because it's so wrong and so crazy. All right, so following the fraudulent assignment from Tripharma to the other parties, he's trying to get comfortable and he can't, and it's so cute. Awaken engaged in an aggressive marketing campaign. Thousands of distributors for its Zenith product. Detailed below, Awaken and the Awaken individuals represented and continue to represent that Zenith is patented technology, while not disclosing that the patent has expired or that the owner of the patent is certainly not Tripharma, Awaken, or Vital, but in fact FFBM. Awaken individual defendants also falsely represented and continue to falsely represent Zenith as the subject of the Yukon study, and they are doctoring the EJAP publication to insert Zenith in place of Tricenix, which we already talked about. That's crazy. There are multiple YouTube videos that falsely claim that they own the intellectual property rights, so the IP rights, and the rights to FFBM's 092 patent, which they clearly fucking don't. On August 27th, 2022, Awaken and the Awaken individual defendants uploaded a 44-minute video entitled Zenith by Awaken, Scientific Product Call. I was going to do a reaction video to that, but it was so boring that I didn't. The video includes remarks by women's health expert Lorna Vanderglugglugl, I don't know how to pronounce that, and I'm not going to try, and counter-defendant Ralph's, where they reiterate Awaken's fraudulent misrepresentations about the origin of Zenith and falsely claim this study was conducted on Zenith when it was not. That's like I said before, you can claim that it's the same product, just rebranded, but that doesn't matter. It has to be that exact product, because the reality of it is that it's not the exact same product. So therefore that's fraudulent. You can't do that. Claim that Zenith is based on patented technology, when in reality, Awakened is referring to the expired 892 patent and the US publication number blah, 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 which is a part of the FFBM patent family that led to FFBM's 092 patent. And it's wild. They can say all day long that they didn't include this slide in their videos, but they did. I mean, I have a saved version of it on my computer. It says, and I'll have Ethan put it on the screen, but it says patented technology, and it's at the top, it says rationale behind Zenith, meaning like, this is why all of this information pertains to Zenith. No, it doesn't. And it has all this information basically that we were just talking about. The patents, the publications, University of Minnesota, like they're really trying it out here. Awaken and the Awaken individuals also have published a 5-minute video of a self-proclaimed fitness and nutrition coach named Colin F. Watson extolling the virtues of Zenith, entitled On Zenith and Awakened Health. It's so culty. In the video, Mr. Watson makes the same false representations pertaining to the origin of Zenith and claiming the 2008 clinical study tested Zenith when it did not. Wild, like the absolute lies. Mr. Watson states that these misrepresentations were made to him by Awaken's CEO. I always want to call her Courtney. It's not Courtney, it's Melinda. Danielle, Courtney, Danielle, same shit. That he reviewed a copy of the doctored publication when he was forming his opinions that he regurgitates in his videos. He threw her right under the bus, which, you know what, rightfully so, if she presented that information as true and he didn't know that it was. All right, so in an attempt to deflect from their own fraud and misconduct, it gets even more crazy. Tripharma defendants repeatedly, not even halfway through this big pour glass. I mean, I guess I've had one glass technically then. Fame FFBM and its CEO, Mr. Caterino, on Awaken's website and through email announcements to Awaken's distributors. That is extremely unprofessional. And if your company that you work for and that you are like ride or die for is going to do that, that's disgusting. Like even companies that like I know have beef don't do that because they're professional. And they're not cults, actually. So a number of Awaken's distributors began contacting Mr. Caterino because through their own research, they had begun to question whether Awaken really had the rights it was claiming to have. Mr. Caterino answered their questions honestly, telling them that Awaken did not have the exclusive rights to the patents and intellectual property. And that's kind of my goal here with this video too, is just like put out all this information for you if you have joined this company. Pointing out Awaken had doctored the EJAP publication by inserting the name of Zenith in place of the studied product, Tricenix. If your product's so good, why don't you just get those studies done, baby girl? Come on. In an attempt to deflect from their own obvious misconduct and fraud, they started to direct their legal counsel, Reed Winthrop, to begin publishing and disseminating false and defamatory statements about Mr. Caterino. God, I feel so bad for this guy. And FFBM on Awaken's website and through emailed announcements to the Awakened distributors. On August 30th, 2022. Awakened sent thousands of its distributors an email containing a statement from Mr. Winthrop, who referred to himself as general counsel for Vital. So not even for Awakened. Awakened isn't owned by Vital, is it? That's weird. But also it shows the connection. Conspiracy. Possibly. Allegedly. I don't know. Mr. Winthrop's statement claimed that Tripharma Vital held the exclusive rights to all intellectual property and claimed that its rights can not be disputed. Even though these rights are very much in dispute in this litigation, as confirmed by its court's denial of Tripharma's motion for preliminary injunction. The statement claims that FFBM and Mr. Caterino had been found liable for fraud in the 2013 judgment when no such findings were in connection with the judgment. My God. Yeah, so they're the lawyer for Tripharma, I guess, which is like, I guess also the lawyer for Awakened, which again just shows the connection between those and like how closely related I guess they are. They're in cahoots, apparently. I don't know. Seems like it, though. He just started spouting out a bunch of being like, well, this company and this man are fraudulent, and they've been, found to be like fraudulent. And then also they've been trying to steal this trademark, and they've been trying to steal all this stuff, and infringers will be cleansed from the marketplace. And then also they never disclosed that the patent was expired and that whatever rights Tripharma may claim are still very much in dispute in this pending litigation. And then on this page, I just have item 66 and I guess paragraph, but item 66 and 67, it just says libel, and then it says more libel. Not only Awakened, but Tripharma, and then also, from what it seems, all of them and the legal counsel for them are just like absolutely just putting out so many defamatory statements against FFBM and the like CEO. It's just like, what are you doing? Like, it's just so sad. My God. So saying that they sound like a Batman villain. It says, stated that Tripharma is seeking to have Caterino hand over all of his fake products. And first of all, if his product's fake, why do you want it? And the patent that he fraudulently acquired, it was literally his to begin with, but thanks. This was clearly intended to refer to FFBM 092 patent, which was not fraudulently acquired. The 092 patent was obtained lawfully through FFBM's patent lawyers and was granted in 2020 over the objection of a third-party challenger, which FFBM assumes was Tripharma, Diamshek, or Mr. Winthrop. That's so crazy. Claiming FFBM fraudulently acquired this patent, the announcement also stated that Mr. Caterino was found liable for patent infringement and fraud, which no such findings were made in connection with the 2013 judgment. So just like making up. It's wild. Absolutely wild. Okay, I know I keep saying like, we're going to speed through this. No, we're not. FFBM's recent discovery of submission to the USPTO of fraudulent assignments of FFBM's patents. So, USPO, United States Patent and Trademark Office. Basically, on September 6, 2022, Mr. Caterino was made aware that publicly available information available on the trademark website basically reflected that FFBM's patents, both the 82892 patent and the 092 patent, had been assigned to Greg Gus earlier this year. So sketchy and just wrong. Like sleazy. Mr. Gus has likewise confirmed that he was never aware of any purported assignments to him or disclaims any knowledge about it. So he's like, I don't know what the fuck you're talking about. I don't know. Like, what are you talking about? Also, you can't assign a patent that someone else owns to someone else without the permission of the original patent owner, which was FFBM, which FFBM is like, clearly we didn't assign out. Like, what? No, we didn't do that. Reported assignments claim that they were made by a court order dated June 8th, 2022, the same date that this court entered the preliminary injunction in the related 2012 action that prevented FFBM from dissipating or conveying any of the intellectual property. FFBM is informed and believes, and thereon alleges, I love that phrase, that these purported assignments originate in some fashion from the Tripharma defendants. I mean, who the else? Come on, who else? Evan, or Dick as I like to call him, Dick Dameshek's criminal conviction for bankruptcy fraud. Get ready, bitch. This is my favorite part. This is the twist that I was like, oh, what? Dick Dameshek, Doug Dimmadome, was convicted of fraud in connection with the Imagentex bankruptcy action. So March 2019, the United States Attorney's Office filed an indictment against Doug Dimmadome and co-conspirator David Greg Lepo. United States versus Evan Doug Dimmadome. I can't stop. I won't be stopped. The indictment charges Doug Dimmadome and Leopard with bankruptcy fraud and 4 counts of false declaration in bankruptcy. The indictment outlines an elaborate fraud scheme that, being serious now, Dameshek and Lepo perpetuated to defraud Imagentex and the Imagentex estate and their creditors, the United States Bankruptcy Court, and Tripharma's former attorneys. So the former attorneys of the company that they worked for. The indictment outlines how Dameshek created fake companies and used fake names in connection with the fraud, which was intended to circumnavigate Tripharma's former lawyers, attorneys' liens, and extort money from the Imagentex estate. Yikes. He pled guilty to 1 count on the indictment, bankruptcy fraud, on July 22nd, 2019. Dameshek's fraud also resulted in Imagentex trustee Gerald Davis filing an adversary proceeding against Tripharma Dameshek Lepo in May 2019. And then a copy of that, whatever. So they were saying that his nefarious schemes had 2 goals, okay? To defraud the former attorneys of defendant Tripharma, LLC, from collecting their fees by circumventing the confirmed Chapter 11 plan of reorganization. So a lot of times when, and this is going to probably not make sense to people, and this is how I understand it, but sometimes when you are filing for bankruptcy, it doesn't always mean that you are actually bankrupt. You actually don't have any money. A lot of times it can just mean that you are reorganizing and like making a plan to reorganize not only your company, but like your funds as well within the company. It can also be like a loophole sometimes. It sucks. Anyways, required all payments to Tripharma under the reorganization plan to be made to the trust account of its former attorneys. So not allegedly, it is confirmed what this person is saying. They said that his goal is basically to get out of paying fees. So fraud, web of lies, and barriers for the debtor to comply with the confirmed reorganization Chapter 11 plan, and to declare phony defaults so that the defendants could either, 1, steal the debtor's intellectual property by foreclosing on the debtor's assets, all the libel, all the defamation, all the back and forth, all the ridiculousness, all the schemes. The Dameshek, the Doug Dimmadome fraud, that's what we're talking about. From how, and again, I'm not a lawyer, but how I'm understanding the adversary proceedings complaint from his fraud case in 2019, May 2019, was that he was trying to be super sketchy and make it real hard for anything to be collected, like any required payments to be collected and put into the trust account for the former lawyers, and then just making it real hard for the debtor, the assets, alternatively force the debtors to pay millions of additional dollars to Tripharma above and beyond what the debtor, so basically just trying to just squeeze them for all they're worth. And that's awful. that's horrible. Okay, so the trustee even noted how Dameshek, Doug Dimmadome's fraud was so damaging that it forced Imagentex to convert its Chapter 11 bankruptcy case to a Chapter 7 case, which I guess is worse. I guess that ain't just reorganization. That is like close it down. Okay, so counter defendants ignore FFBM cease and desist letter. So on September 7th, 2022, FFBM patent attorneys sent the counter defendants a 9-page cease and desist, and the letter outlines with specificity and ongoing infringement and fraudulent actions of the counter defendants, especially to the awakened defendants as well, saying and this is what this part says, is that despite you knowing exactly what you're doing, being shown proof, being shown all of this, that they don't have the rights to send this to you, therefore you don't have the rights to sell this, and that you doctored this, and that you're, faking this, and that this is false advertisement, like, you're still opening up your company. That was September 7th. The company opened, October? So, you still went ahead and opened a month after? Like, I can't imagine, listen, I love money as much as the next right? But I cannot imagine loving money that much to just have a total disregard for what is right and what is wrong. I guess that's what happens when you join a cult though, right? We're almost done. So now we're going to go over claims basically. We're only going to go over a few of them because most of them, I don't want to say most of them, but like some of it's kind of repetitive. Tortious interference with prospective business advantage, negligent interference in prospective business advantage, third counterclaim, unlawful, unfair, and fraudulent business practices, false advertising, patent infringement. Both of those are pretty understandable. I mean, we understand what that is. Trade libel, and then defamation as well. So, good Lord. This is what this company is facing right now. All of them, actually, because it says FFBM against all counter defendants. So that means Doug Dimmadome. Can we just continue to call him that, please? Evan Dameshek, aka Doug Dimmadome, and then also Vital, whatever company he owns, Tri-Pharma, and then also all of the owners and people basically in control of Awakened and the Awakened entity itself as well. All right, so first we have tortious interference with prospective business advantage. So tortious interference just mainly meaning you're interfering in my business. And we know that they have not stopped because they've continued to open the company and sell stuff for it. So again, it's kind of redundant. Basically, like you're interfering in our business and you're costing us money. That's what that is. Not only are you interfering in our current business, tortious interference, but you are interfering in our prospective business going forward as well, which that's real big. So again, basically just saying all this shit is holding them back, not only like business wise, but like financially specifically, cover their attorney fees. They are saying that they're just being fraudulent and unfair and unlawful, like confusing people in the marketplace, basically. Again, I'm not a lawyer. This is just my understanding when reading these. California false advertising law. They're doctoring the Yukon study, the publication, statements and representations that ZENITH derives from the patent when it doesn't. They won't recover financially and they will have to shut down completely unless they are granted relief and damages monetarily, obviously. Patent infringement, according to this fifth counterclaim, it's alleging that Awakened's individual defendants have conduct as alleged herein constitutes infringement of FFBM's rights according to the patent in violation of 35 USC blah, blah, blah. Trade libel, and then the sixth counterclaim, and then the seventh one is defamation. So trade libel, in my opinion, just meaning more so like damaging to like the business specifically and like their business reputation. And then the defamation meaning more so like enticing like harm to the company. Anyways, you'll see. It's libel because they knew it was false, or they just didn't care if it was true or not. Like they just didn't care to find out. Or financial loss for the company. In defamation and libel cases and stuff like that, it's hard to prove the company, the whoever, or the person had like a financial loss or damage or whatever specifically due to this person defaming them. And that's kind of what this is alluding to. So harm was directly due to these defendants and their actions and whatever. And my note here says, it's libel, pay up. That was more specifically for your business loss. This one is more personal. It's more like reputation, right? Instead of just like, you're lying. So it's just like you're perpetuating this. You don't even know if it's true and it's doing damage to someone. So that's not good. I interpret this as defendants are still confused on who has the rights to the IP. Judgment is basically needed in order to be like, no, final time. Not, it doesn't matter what like previous agreements or blah, blah, blah have said, or like this doesn't mean this, or this settlement didn't say this. It's like, okay, but who has the rights to it? Tortious interference with contract. Counter defendants kept going against previous contracts and agreements and court rulings and things like that, and just kept going back and forth, back and forth. We want damages and you have to pay our lawyers. Like, okay, we get it. Do you have to say it on every little thing? They do. And then conspiracy is the 10th counterclaim. And on line 6 here, it says counter defendants have actual knowledge of FFBM's exclusive rights to the intellectual property and to the newer patent, the 092 patent. The Tri-Pharma defendants, on the one hand, conspired with Awakened and the Awakened individual defendants, on the other hand, to circumvent and violate FFBM's exclusive rights to the intellectual property and to the 092 patent. This conspiracy caused FFBM to suffer damages in an amount according to proof. My notes here say they knew they didn't have rights, but they did it anyway. And then the 11th counterclaim, unjust enrichment. And then the 12th is false designation of source and origin. That one's all about patents and the publication and all that. And then the unjust enrichment, basically saying like they were acting maliciously, intentfully, willful, oppressive, and being reckless, you need to pay us because you're mean. Just kidding, obviously. Then 13th, false advertising. Come on. They doctored studies. Curious false advertising and false designation of source and origin. Demand/prayer. So cute. For relief. This is the last of it, saying they are wanting their legal fees paid, obviously. But basically this is what they're wanting. So they're wanting an order for judgment. FFBM has exclusive rights to exploit and use the IP and the newer patent, the 092 patent, to the exclusion of all others. So no one else can use it, including all counter defendants, including all awakened people. So they can't use it either. They can't use the product. They can't sell that, nothing. Counter defendants have violated and continue to violate their FFBM's rights to the intellectual property and that patent. And then also they want an injunction prohibiting them to, again, injunction means like make them stop. Is the best way to explain it. For an injunction prohibiting counter defendants from continued marketing, advertising, distribution, and sales of ZENITH or any other product associated with the intellectual property. So like specifically with their product. For a constructive trust for FFBM's benefit on all revenues derived from the sale of ZENITH or associated with the intellectual property. They want all their revenue, baby. I mean, I don't blame them. I hope they win. I'm gonna try to stay on top of this. For damages, including statutory damages in some in excess jurisdiction, blah blah, that FFBM currently estimates to exceed 75 million. And then for compensatory and then consequential, not that one, damages in a sum in excess of the jurisdictional minimum of this court that FFBM currently estimates to exceed 75 million. Like, companies just shouldn't brag about how much they think they're gonna make, because that's why they put that down. Because Awaken said like, oh, we, or whoever allegedly said, oh, we're estimating that we're gonna make this much money. It's 75 million. And now FFBM is like, give me that 75 million. So I don't know if you like add those together. If you a lawyer, let me know. Like, you add those together, whatever you put down, you're most likely not going to get. You just like have to put down a number because it's civil and not criminal. I get it. But yeah, so like that's like a lot of money for recovery of all of counter defendants' profits incurred in. Okay, so we already talked about that. So basically just give me all of your money, please. And then all of the damages. Yeah, so they're asking for everything. And then also, again, pay our legal fees, demanding a jury trial for all claims. So that's good. Mr. Caterino, hit me up, babe. I hope you're okay. So this is dated October 26th, 2022. Also, I ran out of my pink. I think this is when I ran out of it. My pink highlighter. So I had to use my red one, and it looks like I smeared blood on it. I love that for me. In the call that we're going to watch in my next video, I'm sorry. I'm going to put these out the same day. And in the beginning of that video, I will say, go watch the video I just put out, or I'll put them out like back to back. I'll probably put them out the same day, actually. They launched like right before this. How are you gonna launch when all this is going on and like you know this is happening? Like it makes no sense to me. The fact that some people are still like with this company when this is so messy, like, don't get me wrong, I understand every company has lawsuits. When do employees of the company, of a bigger company, hear about any of those lawsuits? When does the sales department hear about almost any of those? But I feel like it's so unprofessional for like that to leave like your legal department, for your lawyer, your legal representative of a whole different company, to send out a mass announcement to like, I don't know, man. It's just, I understand like keeping people in the loop, but then like actively like defaming. It's all so messy, and it's just not right. And it's gross, and it's not okay. Don't attack anyone who have mentioned this video, please. Again, I'm not a lawyer. I am not stating anything as fact other than what has been stated as a fact with proof in these documents. I find it all fascinating. It's just truly wild to me, like, that this has happened with this MLM, and then they're just like front facing. They're like still launching, still doing great. The one that I'm about to do, they like just launched like a day before or something like that, or like that day. And the call I'm about to watch with you in a next video, and it will literally be posted right after this one, probably, like I said, was posted on October 25th of this year. The day before this was all filed. Again, keep in mind, all this has been going on. They were actively ignoring the cease and desist after they were given all the proof. Like, I just can't like imagine. I can't fathom like being that desperate for money to do that much bad. That much bad? You know. I don't know. My brain cannot fathom it. I hope y'all have an amazing rest of your day. I know this video was different. I know. I'm sorry. I'm sure Ethan will be able to make it as like cohesive and easy to follow as possible. And he'll be putting the things on the screen too, so that you can like see them and it's not just me reading a paper. But yeah, I needed to be able to go over all of that with you so that you could have all the background and see like, oh my God, like this other company is getting screwed over and these people don't even have the rights to it because that's still up in the air. Like, what is going on here? Have a great day, night, weekend, whenever you're watching this. I hope you enjoyed this video. Like, subscribe, and comment, and I will see you in my next one. And please do not join this company. For the love of God. If you know anyone who is joining or wants to join, whatever, if you just please share this video, please. Because we never like know when someone's going to join. We never know when someone's going to be pitched, but if we share my videos, I share my videos, but if we share my videos, then we can get it out in front of people and then we'll be like, oh, hey, I was about to join that company. Let me see what this is about. Don't join this company. This is whack. You do not want to be a part of a company that acts like this. Okay? Okay. All right. I'll see you in my next video. Goodbye.